House Division 1 is now in session.
Thank you. Please be seated. Good morning.
Morning.
We are on the record for oral arguments in case number CR190622. This is State v. Quinonez. A couple of housekeeping items before we get started. First of all, you see two of us here in the courtroom, but Judge Campbell is participating. She's viewing a live stream of the oral argument. So you have three judges participating, just two here in the courtroom. In more normal times, we would invite you to stand at the podium during your argument, but because these are not those times, today we invite you to stay seated at council table throughout the proceedings. As you can see, Judge Morse and I are physically distanced, and we've removed our masks to make it easier to communicate with you during argument. You are welcome to remove your mask during argument if you would like. Of course, if you prefer to keep your mask on, you're free to do so. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you would like. Also, please keep in mind that we have read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Just a quick question on the clock.
Can you see it? You might have to get out of your seat to see that clock there.
Okay. Good morning.
Good morning.
Tim Eckstein on behalf of appellant Charlie Quinonez. There are two sets of errors at issue in this appeal. The first are the trial errors that include the exclusion of relevant evidence, the refusal of jury instructions and argument, which individually and collectively constitute an abuse of discretion and deprivation of due process. And then there are the sentencing decisions, the failure to exercise discretion in imposing consecutive terms, and the abuse of discretion in imposing a 24-year sentence. Turning first to the trial errors. Trial court excluded evidence of victim impairment, a blood alcohol concentration of 0.117, and the victim speeding, driving between 88 and 89 miles an hour just prior to the collision. This evidence is relevant. Relevant evidence is generally subject to admission. Relevance, as this court is aware, is a low bar. It need, in a criminal case, only to tend to create reasonable doubt. Evidence of victim impairment, or really any factor that tends to describe what happened in a case, in this case, a vehicle collision, is generally going to be relevant.
What is the relevance?
Here it is, I think, relevant in three different ways. So the first way, in generally describing what happened that led to this collision. The second way is based on the state's presentation of evidence, which included several pieces of evidence that described the accident from the victim's perspective in a way that suggested to the jury that there was nothing the victim could have done to avoid this collision. The third way in which it is relevant is to allow it to be argued to the jury with an appropriate instruction as a superseding cause. And here let me peel apart the speeding and the evidence of impairment. I think the law is pretty clearly established that speeding alone is foreseeable on an interstate highway, such that it wouldn't be subject to a general superseding cause instruction and could be presumptively excluded on that basis alone. But there is no case that the state has cited or we're aware of that suggests impairment on a driver on any road is foreseeable, such that it isn't subject to a potential superseding cause instruction. And here the trial court...
But why is, other than his ability to avoid the collision, how is impairment relevant at all? How does it change anything that the jury heard?
Well,
the victims, I'm saying when I say his ability to avoid the collision.
Sure. No, so I think it in two fundamental ways. So the first way is based on the state's presentation of evidence. So because the state
Well,
elicited...
that goes to your second point, which is there anything the victim could have done to avoid the collision?
Sure.
Okay, so other than that, other than avoiding the collision, what is impairment relevant to?
Well, it is relevant, again, to the superseding cause instruction, because the jury would ultimately have to consider, is there, if you've got two vehicles that are moving, I'd say, presumptively the behavior of both of the drivers in those vehicles, each one of which could have been a cause of the accident, to allow the jury to make some determination as to causation. Once then you interject into that the question of foreseeability as a potential superseding cause. If there is, in fact, one of them engages in non-foreseeable conduct, and here I would argue that from the perspective of Charlie Quinonez, that's driving the wrong way on an interstate, and presumptively impairment on his part. And I would argue on behalf of the victim that it is the impairment. I think that's ultimately a jury question. The jury needs to decide whether, in fact, that does constitute a superseding cause, such that it's unforeseeable and that it itself led to the collision. Let me put it slightly differently. Imagine everything in the case is the same.
I get the impairment. We generally kind of presume that impairment means your reaction time isn't as good, your decision making isn't as good. But doesn't all that boil down to his inability to avoid the car coming the wrong way down the freeway? Is there anything else you can point to suggest, any evidence at all on the record to suggest that he was the cause of it other than his inability to avoid?
Well, that he drove right into. So you've got two vehicles that, based on the evidence,
one traveling the right way on the freeway and the other one traveling the wrong way.
Well, so I was going to refer to the two vehicles that were headed the same direction.
Sorry.
That's okay. So you've got two vehicles that are roughly close to each other. Mm-hmm. One of them slows down as soon as they see the lights coming towards them. And as that driver, who I believe is Nutter, explains, he sees the victim's car continue to drive directly into the headlights. And we have evidence that it doesn't slow down, it doesn't brake, it doesn't in any way avoid the collision. I agree it is a challenging argument ultimately to present to the jury to suggest that the victim's failure to brake, the victim's failure to steer out of the way, to do anything other than to drive directly into those headlights is itself a superseding cause. But it's one that a defendant is, by rule and by the Constitution, entitled to make as long as the underlying cause itself is not foreseeable. And here, there's no law that suggests impairment is foreseeable. Let me put it slightly differently.
Let me ask another hypothetical then, because I'll tell you, when I first read the briefs, I thought you had the better of the argument. And then I thought about it some more, and now I'm not so sure. And here's what I came up with, and maybe you can just pick this apart and disabuse me of it. But if we weren't in a car, if your client had been walking down the street swinging a sword, and there's people coming this way, and a whole bunch of people go, oh my gosh, there's a crazy person walking down the street swinging a sword, and step off to the side. But I'm blitzed out of my mind drunk and just keep walking and don't even see the guy swinging the sword, and he chops my head off. It doesn't matter that I was drunk. He still hit me with the sword. And I did not cause it, I just failed to avoid it. And those seem to be very different issues. So would my impairment matter in the case of the sword?
It might, but I think that's ultimately a question for the jury. So
tell me how it's relevant. How's my impairment relevant in that case?
In that the jury could make a determination that
I caused my head to be cut off?
That your conduct, and I guess a lot of it depends on the detail, in your hypothetical, and you're walking down the street, but that there are two things that are moving, and both of those things need to be happening at the same time in order to lead to result. I agree that would be an incredibly challenging argument to make to a jury, which I don't think,
because your client swung that car down the middle of the road the wrong way and lopped their heads off.
So here's the hypothetical I've been thinking about that. Like you, I've gone. This is a tough problem, and I've gone back and forth in my own thinking about why it's so difficult to get to. Imagine everything in this case is the same, except that Charlie Quinonez isn't impaired, that he's just tired, and he's driving the wrong way down the I-17. Everything else about the case is the same. In that circumstance, would evidence of the victim impairment be relevant as a potential superseding cause? I think it would have to be. And because it would have to be under that circumstance, it's effectively raising the same question, which is, is there something the victim could have done or did do, either one of those, at that point that was that sort of final cause that led to the collision?
I'll agree with you in that if it was relevant, if your client hadn't been impaired at all, then it would be relevant in this case. But I don't see that it's relevant in either. And that's what I'm kind of getting hung up on, is like trying to figure out, looking at Shumway, looking at Van de Veer, which are the two cases I seem to see most on point. And I understand your foreseeability argument, but there's nothing other than his ability to avoid the collision that I see being relevant, and I don't see that the ability to avoid can be a supervening cause any more than it could be in my kind of crazy sword swinging example.
Well, I understand the court's point. I think, going back to my hypothetical, if in fact the distinction of having impairment or no impairment would certainly make a difference in terms of criminal culpability on behalf of Charlie Quinonez. But from a superseding cause perspective, I don't see how it renders any different what is sort of the ultimate cause. His conduct is the same in terms of he's driving the wrong way on the interstate. From the victim's perspective, everything's the same. There's nothing that's different about, from the victim's perspective, the ability to avoid or drive right into the collision. And that being the case, I think it is ultimately, and I concede it's a difficult argument to make to the jury, but is one that a defendant is entitled to make. Once a defendant clears that bar of foreseeability, I don't think it is up to the court to impose its judgment for that of the jury, which is what the trial court did here.
Counsel, I know time is going quickly. I want to ask you, you'd mentioned one basis that you thought the victim driver's BAC and speeding should come in was based on the state's presentation of the case. Talk to me a little bit about that and what specifically the state presented that would bring it in.
Sure. It was the evidence that the state presented on effectively trying to describe the events in a way to suggest that the victim could not have avoided a collision. So the state brought into evidence what it would have looked like from the perspective of the victim, that the road was, at that point, the interstate was slanted, that it was at a curve, that things were happening quickly, such that this both comes in evidence and argument that the victim wouldn't have had any kind of opportunity. And again, if Judge Morris is right, none of that is relevant. I don't know how that evidence comes in, but it did come in, and that argument was made.
Did you object to it?
I don't. Some of it was objected to, and those objections were sustained. I think there was a video that the state had originally propounded as evidence that was excluded. I don't believe there were objections to that part of the argument and that particular part of the testimony. But once it came in, I think that changes the relevance calculus, because otherwise the jury is left with a conceivably irrelevant, but at least misleading and therefore unfair conception of what transpired in a way that could lead to an unfair verdict. If the court has no more questions on this part of the argument, the second piece of evidence regarding a superseding cause is that of a pre-collision concussion. And what the court did there is it imposed its belief that because Charlie Quinonez testified that he made a decision to get back into his car before driving the wrong way, that therefore effectively the court found that there wasn't a concussion.
A moment of lucidity, I think is what the court referred to, or something.
Either there wasn't a concussion or the concussion didn't affect him in a substantial enough way to render it something credible But what the court didn't do is make any determination regarding foreseeability. And that's the question for the court at that moment, which the court did not consider.
What is the evidence? Because obviously you're entitled to a superseding cause instruction if there is some evidence, and it's not clear to me in looking at the cases exactly where that threshold is, but there has to be some evidence to support your theory. What is the evidence that he had a concussion prior to the accident?
The evidence is his trial testimony that he was experiencing a dreamlike state as he stood in the roadway, and the only other time in his life.
I mean, he didn't say, I remember hitting my head, or any kind of evidence about anything that would have caused a concussion. It was just that he kind of came to in a dreamlike state in the middle of the road, right?
That's correct.
And that would support enough of an inference that there was a concussion as opposed to maybe side effects of inebriation or something else that the court could rely on to find that?
Again, I think that's a question for the jury.
There was no medical finding that he had a concussion, was there, in the record?
No, I believe there is a finding that he had a concussion. The question is whether it occurred prior to the collision or after the collision. I don't think there's any dispute.
Is there any indication at all in the record that he, other than that statement of his, any medical or something, that he had a history of concussions or anything else that the court should have looked at to make that determination?
The evidence is that he had sustained a concussion previously, and what he was experiencing in the roadway at that point, the only other time in his life when he had experienced that dreamlike state, he testified, was when he had previously sustained a concussion.
Okay, so he testified that this was consistent with his prior experience with concussion.
That's correct.
Okay, gotcha. Thank you.
And again, I think the question is just, it's from the trial court's perspective, it's simply one of foreseeability. And if the court doesn't make a determination on that basis, and it didn't, it's imposing its judgment for that of the jury, which it can't do. The denial of...
You have 4 minutes and 35 seconds.
Okay. To touch quickly on the denial of the civil jury instruction and non-criminal negligence, in that instance, the instruction as it came out, although it was the appropriate Raji instruction, in light of In re William G, is an insufficient, and in this particular case, a misleading description of the law as it applies to criminal negligence. And I think it's a deprivation of Charlie Quinonez's constitutional right to keep his lawyer from arguing what is a correct statement of the law regarding non-criminal negligence. I just want to touch briefly on...
I was writing a note and I may have misheard you. I want to make sure. Are you saying that the instruction given on criminal negligence was inaccurate?
It is the accurate Raji instruction, but it is an inaccurate statement of the law, at least in terms of as applied to this case. In a case where a defendant is arguing sort of in a spectrum that there's criminal recklessness, criminal negligence, and civil negligence, I think the In re William G case that this court decided shows that is an incomplete and therefore misleading instruction.
But just so I can distill it down, because in your brief, you don't argue that the criminal negligence instruction was inaccurate.
It is an accurate...
You're saying we should have been allowed to supplement it with additional information, but it's not... the jury was properly instructed as to the standard for criminal negligence. Do you disagree with that?
I disagree that is the correct Raji instruction. I disagree that it is a correct statement of the law, at least as applied to this case. Again, where a defendant is attempting to argue a distinction between criminal recklessness, criminal negligence, and civil negligence, that a more thorough instruction, either through the civil negligence instruction or some of the language from In re William G, needs to be applied. And I just need to touch briefly on the sentencing issues, and then we'll reserve the last couple minutes of my time. A trial court has a good amount of discretion, and for good reason, just sort of given its proximity to the case and the individuals involved and the particular factual circumstances. The record here, though, shows that the trial court either sentenced Mr. Quinonez based on this court's prior decisions clearly in a legal basis in imposing one sentence for consecutive with each other for each victim, or believing incorrectly there was a presumption in favor of that, and then imposed a total sentence of 24 years that is plainly excessive. Looking at it, comparing this case to similarly situated case, looking at this case sort of internally when there are simply not the sorts of factors present that typically allow for what is 1 year short of a sentence that gets imposed for a first-degree murder conviction. And so if the court does not reverse the conviction on the basis of the evidentiary and other decisions, we would ask for, at minimum, a remand for resentencing based on sentencing errors by the trial court. And I'll reserve the rest of my time.
Thank you.
Need a quick sip of water. May it please the court, Assistant Attorney General Alice Jones, on behalf of the state of Arizona. This court should affirm appellant's convictions and sentences because none of the issues he presents on appeal merit this court's relief. I'll begin with the first issue unless you would like me to start somewhere else. The trial court did not abuse its discretion in precluding the evidence of the victim driver's blood alcohol content and the speed of the Versa. Contributory negligence just simply is not an issue in a criminal case. It has to be a superseding intervening cause. The victim's conduct needs to be a superseding intervening cause to become a relevant offense in a criminal case. And that is an incredibly high standard. It has to be unforeseeable and with the benefit of hindsight described as abnormal or extraordinary. And when a defendant's conduct creates the very risk of harm, the fact that a victim's conduct may increase the risk of harm is just simply not relevant. And I think this court has held in several cases that any increased risk of harm is not sufficient to become a superseding intervening cause.
What are some of those cases?
Okay. So I think Van Dever is one of them, and I might be mispronouncing the names. I think Slover is one.
Give me the site on Slover.
I just cited in the answering brief, but it's 220 Arizona 239, and that's a 2009 case. And there, the defendant drove a pickup, left the roadway, rolled down the embankment, and landed in a shallow creek, and the passenger died. The passenger had an extremely high blood alcohol content of a 0.231, and the defendant, one of the defenses he wanted to raise was that the victim was so drunk that he didn't raise his head up out of the water and drowned, and that it wasn't the crash that led him to be unconscious and caused him to die. It was his own intoxication, and this court held that could not be a superseding intervening event. So I do believe that intoxication has been addressed by this court. I think Slover is an example of that, and I also think State v. Krantz, which we cited, 174 Arizona 211, that was a rear-end collision where the victim motorcyclist was intoxicated and was rear-ended by the defendant, and the court precluded the evidence of the motorcyclist's intoxication.
No, go ahead.
Okay. So I believe when it's not, and here it was the defendant's, the appellant's driving the wrong way at highway speeds on I-17 in the very early morning when it's dark outside that created the very risk of harm that any oncoming traffic could be involved in a collision.
Do you agree with defense counsel's or your colleagues' characterization of the state's evidence that the state presented evidence that the defendant or the victim was unable to avoid the collision? Because that would certainly, if that's accurate, that would seem to open the door to, well, maybe he could have if he hadn't been blitzed out of his mind.
That's not my reading of the record. I do know at one point the state did want to bring in a video that a trooper had made of driving at 75 miles per hour to show the road at night and at daytime. And that was, the trial court indicated that if that came in, that might open the door. And so the state decided not to introduce that evidence. I believe, I don't remember if it came in a state's case through a witness or in response to a jury question. It came in that the Versa did not brake. But I don't believe, the closest it probably came is other witnesses describing the collision. And I disagree.
Is there anything in the state's argument that they said there's no way that the victim could have avoided this?
I think that it was argued that way at the motions hearing because the detective testified.
I'm talking about to the jury.
To the jury. I don't believe the characterization of the record. I didn't read the record that way, and I don't think the argument was ever made that the door had been opened from that argument. I think it was the video, and then the argument was the Detective Gear, the accident reconstruction expert, may have opened the door to it by saying he relied on the EDR, the black box of the Nissan Versa, but the state Detective Gear made it clear at the motions hearing that he didn't rely on the victim's speed of the vehicle, the speed of the victim's vehicle in coming to his conclusions, that it wouldn't have mattered whether it was 75 or not.
You heard the hypothetical that I posed to the opposing counsel, and I'll tell you, I can shift that hypothetical slightly, and I'm just as concerned with your argument. So if I set up wire across the road,
Okay.
I've decided to block off the road for some reason.
Okay.
And let's say, I don't know whether it's legal or not, but I've done it. And I put flags on it so that everyone can see the wire. And I've got some signs off to the side of the road that shows that I've got this wire across the road. And I present evidence of 5 different cars seeing it and pulling off to the side instead of driving through it. But one guy on a motorcycle who's drunk off of his gourd drives right through and it lops his head off. Wouldn't I be entitled to present evidence in that case of his inebriation in order to show that I wasn't the cause of the accident?
No, I don't believe so, because I think if it's the conduct of the defendant, that the negligent conduct that created the very risk of harm, any increase in that risk by another or a potential victim does not constitute a superseding intervening cause under Arizona law. And I think in a civil case, that is relevant to contributory negligence or apportioning fault or damages. And I think this court's decision in State v. Freeland, I think has a good discussion. That's 176 Arizona 554, distinguishing between comparative contributory negligence and superseding negligence under Arizona law. And I think they even talk about it could be considered in mitigation, it could be considered by the court in sentencing, but it just simply is not enough of a superseding intervening cause to relieve someone of criminal responsibility. And I think particularly here, a wrong-way driver creates the risk that anyone driving the opposite direction, northbound correctly on I-17, northbound on I-17, could cause a collision. And I just don't think it is unforeseeable, and with the benefit of hindsight, abnormal, extraordinary, that one of those northbound drivers would be speeding and or possibly intoxicated. So I just don't think that can rise to the level of a superseding cause. And for that reason, the court properly precluded the evidence, because if it's not relevant for a defense, I think it can confuse a jury into thinking that contributory negligence is a defense, and that somehow he's relieved of criminal responsibility because of the victim's actions, when under Arizona law, it can't be. And I do think that's a legal determination for the judge. I think this is distinguishable from cases like Shumway, where there is a legal dispute about who had the right of way. So in State v. Shumway, there was a question of fact of whether the victim driver turned into the defendant's right of way and was, in fact, the cause of the collision because the defendant actually had the legal right of way. I think that's distinguishable here when the victim driver is driving northbound on I-17 and it's the defendant who's driving the wrong way. There's no factual dispute there about the wrong way driving. And I did want to point to another case that was cited in the answering brief as well, but is a recent case, and I don't want to mispronounce, but State v. Aragon, which is it was a special action to Division 2, and it's at 249 Arizona 573. And there the defendant was, and this arises in a pre-tower context, but defendant drove 70 to 95 miles per hour in a 45 mile per hour zone, struck the victim's vehicle while it made a left turn and from my reading of that case, there was no dispute about who had the right of way there. And neither the victim nor her infant son were properly restrained, and the victim driver was impaired. She had a metabolite of THC in her system. She was prosecuted for a DUI and for endangerment. Her infant son died. They both were ejected from the vehicle, and the infant son died. And the trial judge granted the request for a superseding cause instruction there. The state special actioned it to this court, and the court held the superseding instruction should not be given in that case, and remanded to see if there was any other reason to, admit this evidence, but said that it would not be admitted for a superseding cause. So I think there are several cases from this court that show that anytime a victim's conduct might increase the risk of harm, it just is not enough to meet a superseding cause.
I want to ask you some questions. You can go in whatever order you want, but I would like to talk about the sentencing a little bit.
Okay.
It is difficult to read the transcript and not view it as the court at least feeling like it was bound to impose consecutive sentences, or at least the presumption was that it has to be consecutive sentences because there were multiple victims. What is your best argument for saying, no, the court was aware of its discretion and chose, based upon its view as the sentencing judge, not to exercise that discretion?
And I do read the transcript differently. I think it has to be considered with the arguments of parties. I mean, I think we start with the presumption that trial courts know and apply the law. And then the parties, both the memoranda from the state and defense counsel, told the judge it had discretion to impose concurrent sentences. And I think the fact that judge took a break actually shows it was surprised. I fully admit, I think it was surprised by the state's sentencing recommendation and wanted to go back and think it through. I think in context, I mean, this is one of the longest sentencing transcripts I've seen about the reasons of imposing a sentence. And it felt that it wasn't a run-of-the-mill DUI case. The defendant had agreed that the state could, or the court could find the aggravating circumstance. It heard from several members of the victims' families and found that the aggravating factor of extreme emotional harm to the victim's family was really weighty in this case. It did find 4 mitigating circumstances. It said it considered them. And of course, the number doesn't mandate one result or another. And I think when it says, how can I not impose consecutive sentence, I think that is a phrase that, based on the facts, based on the circumstances, based on the aggravating and mitigating circumstances, in context, I don't read that as a statement of, I'm bound by the law to do this. I'm bound by the facts of this case and the extreme emotional harm to impose a 6-year sentence per victim in this case.
Does the law impose a presumption in favor of consecutive sentences in this situation?
I don't believe so.
Okay. And your position now is that the court was advised by both the state and defense that there was no such presumption?
Yes, and I believe, and I just, give me one moment. I thought I cited in my brief the Record on Appeal 159 and 161, I think, are the citations to the sentencing memoranda that were submitted by the parties. So I do think, and I don't think I think the states argued it should impose consecutive sentences, but I think it had a range that was lower than what the trial court ultimately imposed. But I do think both agreed, and it was argued to the court that it did have the power to impose concurrent sentences. And I don't think it's a fair comparison. It's always difficult to compare sentences in cases. And the reason I cited the U.S. Supreme Court case in my briefing, I just don't think guilty plea cases are comparable to cases after a jury trial. A recognized part of the guilty plea process, and that is, and that's why I cited the U.S. Supreme Court case. It's acknowledged as an okay part of the guilty plea process. Is you typically will receive a lighter sentence if you plead guilty than if you go to trial. And so when you are comparing cases that are guilty plea cases, I just don't think that is a fair comparison. And even if it's on the higher range, it is the sentencing court's discretion, and I don't think the court relied on any improper factors. I think the court said its reasoning fully on the record, and it was within the court's discretion to impose that sentence. If you have no further questions on the sentencing issue, I can move on to the...
549.
I can move on to the second issue if, I'm here to answer your questions, so if you want me
Please.
to move to another issue. The trial court did not abuse its discretion in refusing a superseding cause instruction based on the alleged concussion. And I think there are several ways to look at this. I mean, first, it's not really a preceding event because it even preceded him getting back into the car. So it really wasn't an intervening event from getting back into the car and causing the collision. But even if it could be something, it just, under Arizona law, I think this court in State v. Dodd, I think this quote is particularly applicable, and that's 244 Arizona 182 paragraph 10. Under Arizona law, approximate cause may be interrupted only when another cause with which the defendant was in no way connected intervenes and but for which the injuries would not have occurred. Again, I agree. I don't think there's sufficient evidence he had a concussion, but even if his testimony is enough, it's not a superseding cause. It's his conduct, again, of driving intoxicated in the middle of the night from Tempe to Flagstaff on a dark road while tired. In his testimony, he admitted he felt tired around 30, I believe it was around 30 miles south of Flagstaff, and yet he continued going. So it's his conduct that originally created this chain of events. So even if he hit his head and suffered a concussion, that's not a superseding event. What I think it can be considered for, and what it was considered for, is his mental state and whether he consciously disregarded a substantial risk. And and the trial court told defense counsel, I'm not making your argument for you, but I think that it's a mental state argument. And they did receive a voluntary act instruction. So I think the way it can be considered is whether he had the correct mental state and not whether it was a superseding cause. So it was fully argued to the jury that way, and frankly, the jury did acquit of manslaughter, so it might have persuaded the jury that he had a lesser mental state. And I do think the admission to causation is relevant to any type of harmless error analysis for issues 1 and 2. Again, the state does not believe any error occurred, but it wasn't just a matter of trial strategy, and I do think it rises to a judicial admission, but he admitted in his testimony when directly asked, did you cause this collision? And he said yes. And defense counsel in closing argument said, I admit, Mr. Quinonez, and I apologize if I'm mispronouncing the name, admits that he caused this collision, and the issue for you is the mental state. So in assessing whether any error was harmful or affected the jury's verdict, when the issue at trial was about mental state, then I just think issues regarding causation did not contribute to the verdict because it was fully admitted by appellant. And finally, I'll briefly touch on the third issue. The trial court properly instructed the jury on the law and did not improperly limit the defense counsel's closing argument.
Our standard of view in that is abuse of discretion.
Correct.
Right? Okay.
Correct. Yes.
And I guess, and based upon your brief, the cases suggest that fear of confusing the jury is a sufficient basis to affirm. And I would get that if you guys had wanted to argue civil negligence or something like that, and they were worried about, the jury might convict on a lesser standard if we even mentioned civil negligence. But we have defense here who's really trying to say, look, this is a higher burden of proof. And I kept thinking back to my days in litigation where you would say the reasonable doubt jury instruction says clear and convincing, and this is a higher standard than preponderance of the evidence. So that's something that's kind of common in this. What is the justification for the court not allowing, I get the instruction, but we're not allowing defense to even really argue like, look, there's this lesser standard?
I think, so So I have two responses to that. I think here, when the objection came in closing argument, my reading of the record is there was a PowerPoint presentation, which I do not see it in the record on appeal.
That's what I read the record suggesting. There was a
PowerPoint.
or a slide or something that he was putting on the thing.
That apparently the way the trial court interpreted it, and I believe the way the prosecutor interpreted it, it was just giving the jury the civil Raji instruction that the court had precluded. And I think because it's not part of the record, it has to be presumed to support the trial court's ruling. But on page 93 of that transcript, and I believe that's August 30th, 2019, the court said, I'm not preventing you from arguing what is and what is not a gross deviation. You just cannot provide this precluded instruction. So that's how I read the court's comments in saying you can't argue this instruction that I precluded, but you can argue, and counsel did argue, what is and is not a gross deviation of the standard of care.
But the court, I read the court still as saying, you can't say, look, there's this lesser standard of civil negligence. Even if the court had said, all right, I don't want you to show the slide, but they went beyond that and didn't let them argue or explain what the civil negligence standard is and why this should have been just considered civil negligence. Do you disagree?
I think it can be read both ways. I will admit I don't think the court's comments were the clearest on that issue. But I think on an abuse of discretion standard, it's, and I do think there's case law that I cited from other jurisdictions on page 37 of the brief that can become mixed concepts of what's a criminal negligence and a civil negligence. And I think that is different from a reasonable doubt standard where it's saying the state's burden of proof, where when you start discussing what is criminal conduct and what's non-criminal conduct, I mean, are you going to start giving the standard for what is civil assault versus criminal assault? So I think it starts muddying the waters there if you start discussing what could be civil rather what's criminal.
I know I've kept you long and
Oh,
we're out
I
of time,
apologize.
Can we give the
Yeah, we
defense
went
an
about a
extra
minute over, so
Okay.
we're going to add a minute to appellant's time. And as you begin, let me ask you this question. Ms. Jones had argued that your client had admitted under oath that he caused the accident, and trial counsel conceded that point. Speak to that for a moment.
Sure.
That
those
waiver?
admissions come, I believe, when the cake is baked. The evidence regarding potential superseding cause has already been excluded. That of the victim's impairment primarily. So when he's admitting causation, the harm has already occurred. I would say number one. Number two, it is not, again, a judicial admission or sort of legal causation that he's acknowledging. What he's acknowledging at that point is that, yeah, he was a cause of the accident. I don't think there's any question about that. But those two things I don't think in any way undermine his ability to argue that the error was non-harmful given the proceeding that led to that. I want to follow up on a couple points that were raised. The first is what the state had said its argument, and this is cited at page 24 of our opening brief. So the prosecutor argued in closing, and so traveling up I-17, it would be difficult to see a wrong-way driver coming at you. It was very dark. I think the state explicitly at that point talks about from the victim's perspective in a way that makes relevant the question of whether the victim could have avoided the collision. So the question of what the trial court believed or understood about the presumption related to consecutive or concurrent sentences and what the court had been informed, in its sentencing memorandum, the state cited State v. White for the proposition that, quote, consecutive sentencing is appropriate where a defendant has injured more than one individual as a result of a single act. This is cited at page 27 of our opening brief. The way that is phrased is not to suggest, and I don't believe the state ever told the court, this is something that is permissive. This is the first, I believe the only time the state mentions the question of consecutive or concurrent sentences. It does so in a way that it misleadingly states what the law is. In the sentencing hearing itself...
Quickly wrap up.
Okay. What the prosecutor says is that a 10 to 17.5-year sentence is appropriate, and there's multiple ways for the court to get there. But doesn't return to the question of whether there's some sort of presumption.
Council, thank you both for your arguments. You have given us much to think about. We will take the matter under advisement and issue a ruling in due course, and we are adjourned.